The Peaceful Streets Project was recently organized. It's a direct action movement with the goal of educating individuals, communities, and families about their rights, and also providing the tools and networks and community necessary for them to feel confident in exercising their rights. It was organized in large part in response to a lot of the police abuse and misconduct that's been taking place in Austin lately, from APD shooting of unarmed young men in the east side of town to activists getting arrested for filming police officers. The idea that we don't have control over anybody else except for ourselves. So in order to make change, in order to create a more free, just, equitable society, we think it's important for individuals to not only understand their rights, but also feel comfortable and confident in exercising them. So what the Peaceful Streets Project is going to be doing in order to encourage that confidence and that knowledge of what our rights are, we're going to be holding several Know Your Rights trainings like this one today. So I want to welcome you to the second Know Your Rights training. We're going to be hearing from Kaya, who's an attorney who has a lot of civil rights and civil liberties experience. She graduated from Columbia University, got her undergrad there, and then went to UC Berkeley to get her law degree. And she did a lot of work in New York City about civil liberties and First Amendment issues surrounding some anti-war protests.
Like John said, I'm an attorney. I'm licensed in New York. I recently relocated back to Austin. Even though I am an attorney, this is not intended as legal advice. Okay, this is general information to help you be familiar with the constitutional rights that you have to help you handle police encounters. But if you do have, a specific incident, specific case, you do need to consult an attorney and get individualized legal advice for that. What I'm presenting on here today are your constitutional rights that apply to all levels of law enforcement. That means the APD, the Sheriff's Office, local police, university police, FBI, ICE, immigration. Okay, basically anybody who's law enforcement who has a badge, these basic constitutional rights apply. Essentially, there are three basic types of encounters that you can have with the police. Okay, the conversation, the detention, and the arrest. So I'm going to cover the different rights that you have in each of these situations, and then what you should say and should not say in each of these situations. The conversation, or the stop, as they refer to it here in Texas. This is no different than talking to anybody else. Okay, just because it's an officer and they're in uniform, there's no special rights that apply to you, and conversely, they have no special rights to do anything other than what anybody else in the street would be able to say to you. This is like, they'll call it, I have different terms for it in different places. Sometimes they'll call it like a mere conversation or a stop, right? And this is like when an officer just walks up to you out of the blue in the street and is like, "Excuse me, can I just ask you a few questions? Can I talk to you for a minute?" So police have the same right as anybody else to just walk up to you out in public and say, "Excuse me, can I talk to you?" Just like I can say that to you, right? Now, you don't have to answer any questions at this level. In the same way that if I walk up to you, you don't have to answer any questions. Okay, they're no different. If you do speak to them, it's considered voluntary. Okay, so just remember that officers are trained to get incriminating information out of you, and just always keep that in mind. So if you do talk to them, you may end up giving them the information that they're looking for, that they need to detain you, arrest you, or prosecute you or somebody else. Okay. If a cop walks up to you on the street and is like, we have a little sample dialogue here. Well, first of all, you want to stop. You want to sort of take a deep breath, okay, relax. All of your actions can be misinterpreted in a police report, right? And you never want to give them any ammunition to use against you or to give them any reason to be suspicious of you. So you would politely but firmly refuse to speak to them. So we have a sample little dialogue, right? The officer comes up to you in the street. "Excuse me, can I ask you a few questions?" You would say, "Are you detaining me, or am I free to go?" Okay, and this one's important. Say, "I don't wish to speak to you. I have to go. I don't want to talk to you. I have to go." Walk away. Get out of there. You always want to make your refusal to speak to them clear in words. You want to articulate that. as opposed to sort of simply shaking your head or, making a gesture or something like that. In legal terms, that could be considered an agreement, silence being an agreement, construed as agreement. So you want to be as clear as possible. You want to say it in words. And know also that most officers, many officers have a recording device, and a lot of the time it's part of the uniform. Okay, so everything that you say during this conversation, during this stop, could potentially be recorded and used against you. So you want to get out of there. Okay, you have no reason to talk to them the way that you wouldn't to a random stranger. And a few things to remember: you never want to run away from an officer if you can help it. Okay, especially in this kind of before anything's escalated, right? First of all, it's not safe. Okay, remember they're armed, and you never want to do anything like make any sudden motions, sudden movements, just for your own safety. Also, the officers can change their mind and detain you. So if you run away, they are likely to use that as a reason to detain you, which may end up leading to your arrest. Okay. Now, detention means that although you're not under arrest, you're not arrested, you're not free to leave. Okay. And basically, this happens in two types of instances. One is they're writing you a citation, like a traffic ticket, and the other is they don't have enough information yet to arrest you. Getting pulled over is a detention. Okay. When you get pulled over in a car, you're not free to go, right? Until they tell you that you're free to go. You're being detained. Okay. The moment that you're not free to leave is when those constitutional rights kick in. Right to remain silent, right to an attorney. This is why officers have an interest in keeping things at this stop level, at this conversation level, because you don't have those rights at that point. So you want to make them clarify whether you're free to go or not. The second you're not free to go, your constitutional rights kick in. Police are no different during that conversation phase, that stop, than I am. So if you don't know me, and I walk up to you in the street and I'm like, hey, how you doing? Where are you coming from? That's crazy, right? You would tell me to, right? Like, it's nuts. Like, why would you do that? So, police, even though they're in uniform, it's no different. Think about it as like a random person who's like telling you to do stuff, okay? Now, the officers know this. So they're interested in keeping it ambiguous and keeping it unclear, because then in court they can say, well, no, there was no detention, there was no rights violation, they were free to go. I just asked, well, where are you going? Where are you coming from? Take out your stuff. She just did it. She just showed me. This part here, this is another sort of sample conversation, and it's just like, the first bit, right? Except here, you're not free to go. So the officer says, excuse me, can I ask you a few questions? You say, are you detaining me? Am I free to go? And they say, no, you can't go anywhere until you do this or that, until you answer my questions. Okay, you can't go anywhere, you're being detained. You would say, why am I being detained? Officers technically, legally, can only detain you if they have what's called a reasonable suspicion, which ostensibly is more than just a mere hunch under the law. So they have to be able to put their reasonable suspicion into words, okay? So it's called the articulable suspicion provision. It means that they need to be able to articulate, to put into words what it is that they suspect that you're involved in. So they can't just say, for instance, well, she was sitting there and she was looking kind of shady, right? So I detained her. Okay, that would not meet the reasonable suspicion standard. But do they do that? Yeah, all the time. Okay, so for this reason, it's important to ask, why am I being detained? And then you remember that, what they tell you, to the best that you can. As soon as you can, you write it down. Because if what they tell you is then different from what was in the police report, that can help your defense attorney later in court to help your case. Remember that anything that you say while you're being detained, this is before they've even arrested you, right? Can and will be used against you. So you want to stay calm, you want to stay in control of your words and actions. If you ask, why am I being detained, and they don't say anything, they might not. You want to be on the record as having asked. You want to get that out there. Certainly if there's, it's being recorded on the dash cam, on their uniform, hopefully there's witnesses or someone else is recording. That's why it's important to have as much evidence as possible and then be on the record as saying, well, I asked, they didn't tell me. You don't want to argue. You don't want to try and explain yourself. You don't want to, explain the situation away. You don't want to answer any questions that will allow the police to engage you in conversation. Okay? If they ask you anything at all while you're being detained, you invoke the magic words. I'm going to remain silent. I want a lawyer. This invokes your constitutional rights that protect you during interrogation. So when you say this, the officers are legally required to stop asking you questions. They might not stop, okay? You might have heard of this, right, as the Miranda warnings, the Miranda rights, after the Supreme Court case, Miranda v. Arizona. It applies to interrogation. When they're asking you questions, you're not free to leave, even when they haven't arrested you. They might not stop. So if they do that, just keep repeating, I'm going to remain silent, I want an attorney, or you're just silent until eventually they'll get it, okay, that you're not going to say anything. During detention, they can pat you down, the officers can pat you down. This is supposed to be if they suspect a concealed weapon. You never want to physically resist an officer, ever, okay? It's extremely unsafe, it could get you killed, frankly, and it will certainly get you arrested. So, you want to fight those battles out in court, okay, not in the street. You're never going to win with the cop in the street. The legal basis for the pat-down while they're detaining you is, it's called imminent threat of serious physical injury. It's there to protect the officer, and the means that the officer can only go so far, technically, as to make sure that you don't have a concealed weapon. They're only supposed to go so far during the pat-downs to make sure that you're not a threat, that you don't have a concealed weapon on you. Technically, they can't pat you down and find your bottle of Tylenol and open it and find the pot that's inside, okay? Technically, they're not supposed to do that during a pat-down. Do they do it? Yeah, all the time. After they pat you down, they might ask if they can search your things, your car. Most likely they won't ask, they'll just do it. They'll just, pat you down and start, just going through your bags, going through your pockets, opening your car, going through your things. Okay, if that happens, you want to make it clear that you don't consent to the search. You have the right to refuse all searches, okay, if you're not under arrest. So, this is when you say, I do not consent to the search. Very clearly, okay? You don't want to be vague, because if you say something like, officer, I'd rather you didn't search me, they are going to interpret that as a reluctant consent. Okay, they're going to say, well, they weren't happy about it, they consented. Okay, so you want to be clear. You just want to say, I don't consent to the search. And again, it might not stop them. It might just keep going, keep going through your stuff, keep going through your car, and you stay calm. Okay, you don't argue with them, you don't get in their face, you don't, try to assert your rights with them. You could do that if you want to take on a more activist role. Just know that, that might lead to you escalating the situation. So, the safest thing to do would be to just keep repeating, I don't consent to the search, I don't consent to the search, and again, hopefully there'll be witnesses, hopefully there's a camera, and this is going to be very helpful to your attorney, your defense attorney later on if you're arrested. Be careful on something called casual consent. So this is if you're pulled over, for instance, and they ask you to get out of the car, and you decide to get out of the car, but you leave the door wide open behind you, and you don't close it. They have searched a car in those kinds of in those circumstances, and claim that they thought that you were you're indicating consent by leaving the door open. Okay, that's happened. All right, so if you can remember that you're in that kind of situation, you want to be careful of those kinds of things. Yeah, anything in plain sight. That's true for your car as well. Okay, so they pull you over for your headlight being broken or something, and then you roll in the window and you have something on your seat there. If it's in plain sight, that's probable cause. Same with the house. They open the door, they look behind you, you got some contraband on your table there, that's enough, okay? Probable cause, you can be arrested. They can also, and this is why you want to close the door, also because they can follow you. If you go into another room, they're allowed to come, to go with you. So you want to just step outside, close the door, done. That's the most important thing, right? You want to fight the officers in court, not in the street. You're never going to win in the street, okay? It's going to hurt. You're going to get hurt. You're going to get arrested. Another thing on detention, providing ID. Okay, so whether you are required to identify yourself to an officer when you're detained, this is not arrested, okay, once you're arrested, you do, but this is going to vary from state to state. These are called stop and identify laws. Increasingly more and more states are passing them. It's a growing trend. There's about, I think 24 now, about half the states have some kind of stop and identify statute to where you're required legally to provide ID just during a detention. In Texas, it's technically refusing to identify yourself when you're detained, unless you're driving. Okay, if you're driving, you have to show your license, right? But if you're not driving, technically it's not criminalized. Now in practice, they usually ask for ID. Okay. Yeah, maybe legally they can't arrest you if you're not identifying yourself, or maybe it's ambiguous, or maybe it's unconstitutional, right? But we know that refusing to identify yourself in this kind of situation is going to escalate it, most likely. Okay, it's going to annoy them. They're not going to be happy with you. They probably escalate the situation, so you may end up getting arrested. So people have all sorts of reasons to not cooperate in these kinds of situations. So we know that just because police legally can't do something doesn't mean that they don't do it.